Good morning, Alex and friends. I'm Grace. Today is Friday, August 7th, 2026, and you're listening to Alex's News. The high in Riverside today will be 96.3 degrees, and the low will be 70.8 degrees, so please be sure to find some shade and stay hydrated if you are heading out. It is Friday, August 7th, 2026, and a meaningful day as we observe National Purple Heart Day to honor those service members who have been wounded or killed in combat. On today's program, we are examining Donald Trump's strategy for limiting birthright citizenship following recent developments at the Supreme Court. We will also explore how proposed updates to the Head Start program could reshape the landscape of early childhood education. We have these stories, plus several other important updates as we head into the weekend. Stay with us for all of this on Alex News. Good morning, everyone. We're following a major immigration story out of Washington this week. President Donald Trump has signed 2 executive orders taking aim at birthright citizenship. Our reporter Ethan has been tracking it. Ethan, good morning. What exactly did the president do?
Good morning, Grace. So yesterday, Thursday, August 6th, President Trump signed 2 executive orders during an Oval Office ceremony. This is a fresh attempt to restrict birthright citizenship after a big legal defeat earlier this summer. According to the Los Angeles Times and Blue Wind, the administration is now taking a narrower approach than before. Instead of one sweeping ban, they've split the effort into 2 targeted orders.
A narrower approach. Let's start with the first order. What does it cover?
The first one targets what's called birth tourism. The Los Angeles Times says that's defined as any foreign national entering the U.S. on a non-immigrant visa, specifically to give birth on American soil. It also covers anyone helping facilitate that, including foreign fathers who use surrogates already here in the country. President Trump said wealthy individuals have built entire businesses around this practice, and he called it, quote, a disgrace, end quote. His top immigration advisor, Stephen Miller, went even further at the ceremony.
What did Stephen Miller say?
Miller declared during the ceremony that birth tourism is, quote, hereby banned, end quote. Now, in practical terms, the order directs the state and Homeland Security departments to ramp up their controls. That means revoking or denying visas for anyone suspected of participating in birth tourism. So it's really an enforcement play, leaning on visa power rather than trying to rewrite citizenship law directly. That distinction matters a lot for how the courts may view it.
Understood. And the second order, what's the focus there?
The second order is about restricting citizenship documents for very specific categories of children. According to both the Los Angeles Times and Blue Wind, federal agencies are ordered to withhold citizenship documents from children born here if neither parent is a citizen and one of the parents falls into certain groups. It's a targeted list, not a blanket rule. The administration argues these are narrow, historical exceptions rather than a wholesale change to birthright citizenship.
Can you walk us through who's on that list?
Sure, the first category is a parent who's a member of a foreign terrorist organization. The second is an ambassador, a foreign government employee, or someone working in a foreign embassy or consulate. The third, according to RTE, is a person classified as an, quote, alien enemy, end quote. And the fourth is a parent who paid for a surrogate in the U.S. or was, quote, engaged in a commercial transaction to purchase or access birthright citizenship, end quote.
That last category ties back to the surrogacy issue you mentioned. Is there anything in this order about taking citizenship away?
Yes, and this is the part that's raising a lot of eyebrows. Blue Wind reports that the second decree also gives the U.S. government discretion to retroactively revoke citizenship. That would apply if citizenship was obtained under, quote, false pretenses, end quote. So it's not just about future births. In theory, it opens the door to reviewing citizenship that's already been granted, which legal experts say is deeply controversial and largely untested at this scale.
Now, all of this follows a Supreme Court ruling. Remind us what happened there.
Right. Back on June 30th, so a little over a month ago, the U.S. Supreme Court rejected the administration's previous attempt to end birthright citizenship. That earlier effort targeted children of immigrants who were in the country illegally or temporarily. The court ruled 6-3 that the president simply cannot undo a constitutional guarantee by executive action. It was a significant setback, and it's the reason we're now seeing this narrower strategy.
And what did the justices actually say in that decision?
Chief Justice John G. Roberts wrote the majority opinion, and he was joined by Justices Kagan, Sotomayor, Jackson, and Barrett. Roberts wrote that the 14th Amendment extended a promise to every freeborn person in the land. He described citizenship as, quote, the right to have rights, end quote. The court also pointed out that words like, quote, lawful, end quote, or, quote, temporary, end quote, don't appear in the Constitution. So in their view, those terms are irrelevant to who gets citizenship at birth.
What about the justices who didn't fully join that opinion?
Justice Kavanaugh concurred, but he based his reasoning on separate federal law rather than the constitutional argument. Then Justices Gorsuch, Alito, and Thomas dissented outright. So the split wasn't a simple party line divide. Barrett, for instance, sided with the majority on the core constitutional point. That 6-3 margin gives you a sense of how firmly the court came down on this the first time around.
Let's talk about that 14th Amendment. What does it actually say?
The key language reads, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, end quote. That's the heart of the whole debate. President Trump has argued the amendment was originally intended only for the children of slaves following the Civil War. He's called the June 30th ruling, quote, very unfair, end quote, and, quote, unfortunate, end quote. So the historical interpretation is really where both sides are dug in.
How is the White House defending these new orders against that ruling?
White House Staff Secretary Will Scharf made the case. He claimed the new orders use, quote, legally validated means, end quote. And he argued they don't violate the Supreme Court's findings because they focus on narrow historical exceptions to citizenship. In other words, the administration says it's not defying the court. It's working within the small carve-outs it believes the Constitution already allows. Critics, as you might expect, aren't buying that argument.
Let's get to those critics. What are lawmakers saying?
The pushback was immediate and sharp. California Governor Gavin Newsom responded by simply posting the full text of the 14th Amendment to X. Senator Alex Padilla said the president does not understand the Constitution. And Senate Minority Leader Chuck Schumer called the move, quote, blatantly illegal, end quote. Schumer predicted the administration would lose again in the courts, echoing what happened in June.
And what about the advocacy groups?
They've been just as vocal. The ACLU denounced the orders, and its deputy director, Cody Wofsy, said they'd meet the same fate as the previous attempt. Deborah Fleischshaker of Unidos US said birthright citizenship is a constitutional guarantee that's not subject to a president's, quote, whims, end quote. And the Women's Refugee Commission warned the orders could trample the rights of pregnant women who are seeking lawful entry into the country. So there's real concern about the human impact here.
Is there any support from within the administration beyond the president?
There is. Vice President J.D. Vance expressed his support on X, saying the moves are necessary to, quote, restore sovereignty, end quote. That framing, sovereignty and control over who becomes a citizen, is really the through line for supporters. They see this as reclaiming authority over the border and immigration system. Opponents see it as an unconstitutional overreach. So the two sides aren't just disagreeing on policy, they're disagreeing on what the Constitution even means.
You mentioned birth tourism earlier. Do we have any sense of how common it actually is?
That's a good question, and the honest answer is the data is limited. Official government figures on birth tourism just aren't available. But RTE cites a 2020 analysis by the Center for Immigration Studies. That analysis estimated somewhere between 20,000 and 25,000 mothers traveled to the U.S. for birth tourism in a single year, between 2016 and 2017. So it's a real phenomenon, but the numbers are estimates, not hard counts.
How does that compare to the overall number of births here?
For broader context, there were 3.6 million births in the U.S. in 2025. So even taking the high estimate of 25,000, birth tourism represents a very small slice of the total. Critics point to that gap to argue the orders are targeting a narrow issue with sweeping constitutional consequences. Supporters counter that even a small number reflects a system being exploited. Either way, expect this to land back in the courts quickly.
So the legal fight is really just beginning here.
Exactly. Given the June 30th ruling and the immediate promises of lawsuits, these orders will almost certainly face challenges within days. The big question is whether the administration's narrower framing survives, where the broader attempt failed. We'll be watching the courts very closely in the coming weeks.
Important story. And we'll keep following it. Ethan, thanks so much for breaking it all down for us this morning.
Happy to, Grace. Thanks for having me.
Welcome back. This morning, we're looking at a major shakeup to one of the country's oldest early education programs. The Trump administration wants to overhaul Head Start, and the changes could touch hundreds of thousands of families. Our reporter Chloe has been digging into it. Chloe, good morning.
Good morning, Grace. This is a big one. As of today, August 7th, the U.S. Department of Health and Human Services has published what's called a Notice of Proposed Rulemaking. That's the formal first step toward changing federal rules. And in this case, they want to significantly deregulate Head Start, pushing control away from Washington and towards states, parents, and local providers.
Let's back up for folks who don't know it well. What exactly is Head Start?
Sure. Head Start launched all the way back in 1965, so it's more than 60 years old now. It's the nation's early education program aimed at low-income families, and it currently runs on a budget of roughly $12 billion. It serves more than 700,000 vulnerable children, from birth up to age 5. So we're talking about a program woven into communities across the entire country.
And who qualifies for it right now?
Eligibility is generally limited to families at or below 130% of the federal poverty line. For a family of 4, that's about $41,795 a year. But there are some automatic pathways in too. If a child is in foster care, experiencing homelessness, or the family receives SNAP benefits, they qualify automatically. So it's really designed as a safety net for the most vulnerable kids.
Okay, so what's the administration actually proposing to change here?
The core idea, according to reporting from NPR and Wisconsin Public Radio, is to move away from what officials call one-size-fits-all mandates from Washington. Alex Adams, who's the HHS Assistant Secretary for Family Support, argues those mandates drive up costs and get in the way of local decision-making. And he's talking about the 1,600 providers nationwide who run these programs on the ground.
One size fits all is a broad phrase. What specific rules are on the chopping block?
Quite a few, actually. The administration proposes removing federal requirements on group size, on specific classroom ratios, and on standards for child development, educational quality, and child safety. Those are the kinds of baseline rules that have shaped what a Head Start classroom looks like for decades. The idea is to let states and local providers set more of those terms themselves.
What about kids with disabilities? Those services can be a lifeline.
That's one of the most sensitive pieces. The proposal includes eliminating specific requirements for serving children with disabilities and multilingual learners. Now, there's an important caveat here. Documents from the Federal Register indicate that some requirements would still apply, specifically around referring and supporting children eligible under the Individuals with Disabilities Education Act, or IDEA. So it's not a complete removal, but the specialized supports would be scaled back.
And I understand family and health services are affected too?
Right. Federal standards for family services, including maternal and infant health, are targeted for removal. According to the Federal Register, the administration wants to reduce what it calls the hyper-specificity of parent and family engagement requirements. One concrete example, they'd remove the 40-to-1 staff-to-family ratio that currently governs the partnership process. So the rules dictating how closely staff work with each family would loosen considerably.
What moves to the states under this plan?
a fair amount of authority shifts down to the state level. That includes background checks, transportation practices, and education requirements. And there's a real emphasis in this proposal on the role of parents. The administration is highlighting nutrition, exercise, and the idea of parents as a child's primary teacher. They want to integrate more parental opinion into classroom curriculum and structure.
Now, there's also a money piece to this. Walk me through that.
This might be the biggest single change. As NPR reports, the administration wants to lower the cap on administrative overhead from 15% down to 5%. Alex Adams says that shift would save the government $2.2 billion. And the plan is to reinvest that money back into the program, creating 200,000 additional spots for children.
More spots sounds like a win. So why are advocates so alarmed?
Because critics say the word flexibility is really a euphemism. Jenny Maurer of the Wisconsin Head Start Association and Ruth Schmidt of the Wisconsin Early Childhood Association, or WESA, warn that flexibility means weakening the minimum quality protections. Those are the rules that guarantee a child gets consistent services no matter where they live. Their fear is that stripping the baseline standards leaves quality up to chance.
And that administrative cut? 5%. Does that worry them too?
It does, quite a bit. Selena Roldan Cirillo and Yvette Sanchez Fuentes of the group Start Early raised concerns that the 5% administrative cap could actually trigger staff layoffs. Here's the part listeners may not realize. Administrative funds often cover specialty staff, the very people who deliver services to children with disabilities. So a cap meant to trim overhead could unintentionally cut the specialists families depend on.
So the savings might come at a real cost to services.
That's the argument critics are making, and Erica Phillips of the National Association for Family Childcare put it in a way that really sticks. She worries that without evidence-based federal standards, the quality of a child's education would end up depending on their zip code. In other words, a kid in one town could get a strong program, while a kid a few miles away gets far less.
There's also a political backdrop here, isn't there?
There is, and it's heightening the tension. The move is playing out against the influence of the Heritage Foundation and its Project 2025 blueprint. That blueprint has previously called for eliminating Head Start entirely. So because of that history, some advocates see this deregulation not as reform, but as a first step toward dismantling the program altogether.
How is the administration responding to that fear?
Well, notably, Health Secretary Robert F. Kennedy Jr. actually cited the program as a success when he announced these changes. So the administration's public message is that it's improving and expanding Head Start, not gutting it. But given the Project 2025 connection, skeptics aren't reassured. That gap between the framing and the fear is really driving the debate right now.
So this isn't final yet. What happens next?
Correct, nothing's locked in. The proposal was published in the Federal Register today, August 7th. That opens a 60-day window for the public to submit comments and weigh in before anything is finalized. So people who care about this, on either side, have until early October to make their voices heard.
And if the changes do go through, when would families feel them?
It depends on how the process unfolds after that comment period closes. But officials estimate the new standards could take effect anywhere from 6 months to a year down the road. So even in the fastest scenario, we're likely looking at sometime in 2027 before parents and providers see real changes in the classroom.
Before I let you go, what's the one thing you'll be watching most closely?
Honestly, it's that 5% administrative cap and what it means for specialized staff. Because that single number connects the money story to the services story. If those specialists get cut, the impact on children with disabilities could be immediate and very concrete. So I'll be tracking how providers say they'd actually absorb that change on the ground.
Really important reporting on a program that touches so many families. Chloe, thank you for breaking it all down for us this morning.
My pleasure, Grace. And we'll keep following it as those public comments come in.
That's Chloe, with the latest on the proposed Head Start overhaul. We'll have much more news right after the break, so stay with us. Here are some other headlines. Turning our attention to the halls of government, things are getting a bit heated in the Senate. In a decision that really split the room, the Homeland Security and Governmental Affairs Committee voted 8-7 along party lines this past Thursday, August 6th, to hold Dr. Anthony Fauci in contempt of Congress. Now, usually this process follows a strict recipe, with the resolution heading to the full chamber for a vote before being certified and sent to the Department of Justice for a decision on prosecution. However, Senator Rand Paul is looking to cut the line. He says he intends to bypass the full Senate vote and hand-deliver the resolution directly to the Department of Justice, essentially trying to fast-track the legal process. Of course, not everyone thinks this move is a winner. Donald K. Sherman, a former official under the Biden administration, told Time that Paul's plan is nothing more than silly theater and carries no legal weight. It seems the senator might be barking up the wrong tree, as a 2023 Congressional Research Service report suggests that bringing the matter to the Senate floor is actually a necessary step based on judicial decisions and congressional practice. If this legal drama actually reaches a conviction, the stakes are quite high, with potential penalties including fines up to $100,000 and a prison sentence ranging from 1 to 12 months. Talk about a bitter pill to swallow. In other news, the medical world is getting a high-tech upgrade. On August 5th, the FDA officially gave the green light to Moderna's mRNA influenza vaccine. This is a historic shot in the arm for public health, marking the very first time a flu vaccine utilizing mRNA technology has been approved for use. It looks like the future of flu prevention is finally catching up to us. Moving over to the international stage, there are unverified reports suggesting that Iran and Oman have reached an agreement regarding the Strait of Hormuz. We are still waiting for confirmation to see if this deal helps keep the waters calm in the region. And finally, in legal news, there are unconfirmed reports that the Attorney General is pledging a national abortion ban. We will continue to monitor these stories as more evidence comes to light. That's all we have for now. Today's episode was made by Alexander King with Claude Opus 4.8, Gemini Pro 3.1, Gemini Flash 3, and Google Cloud Text-to-Speech. I hope you have a great day. I'll see you tomorrow, Alex.